Ladies and gentlemen, my name is Tony Gallo with the National Press Club, the world's largest organization for professional journalists. If you are interested in joining, please see us afterwards and we will direct you to the right people. This is a historic day because it is the first child abduction newsmaker we have had in the club's 108-year-old history. And it is a heart-wrenching story. And with that, we will begin. Our speakers are first, and could you raise your hand? Chris Brann. Chris is a doctor in Houston, Texas at Baylor University. He is the father of Nico, who is at the very core of this whole kidnapping event. Secondly, we have Jared Genser. Jared is with Perseus Strategies. He is an advisor at Harvard University. He is a reporter for U.S. News and World Report. We have done 5 newsmakers together, and it seems the last one he was here with another attorney named Amal Clooney trying to get the former president of the Maldives out of jail. Next to him is David Goldman. David is the father of Sean Goldman. His story parallels, or is very similar to Chris's story, and they were able to retrieve Sean from Brazil, who was kidnapped by his non-custodial mother. And to our left here, we have Ambassador Michele Bond. She oversees 13,000 employees at the State Department who take care of incidences like this, which affect Americans abroad and in the United States. Showing up shortly will be Congressman Chris Smith, 18-term congressman from New Jersey, who was responsible for passing, the Bringing Sean Home Foundation and landmark legislation to help children who are kidnapped. And I would like 2 other people to stand up. Ambassador Susan Jacobs, just wave to the camera. Ambassador is in charge of children's issues at the Department of State. And Sergio, wave to the camera, Sergio Botinha, who is Chris Bin's lawyer in Brazil. With that, I've spoken long enough. And Chris, will you begin? We will have questions. The speakers will be on for about a half an hour, and then we will have questions from you. Thank you.
Thank you very much. My name is Chris Brann. First, I'd like to say thank you, obviously, to the people who are on the panel with me, my attorney, obviously, David Goldman, and Assistant Secretary Bond. And thank you for my attorney from Brazil as well accompanying me, and obviously Ambassador Jacobs. I appreciate the show of support. So my story obviously begins with the birth of my child, but where this really starts is on July 1st, 2013, when he was illegally taken out of Texas to Brazil. I met my ex-wife in graduate school in Houston, Texas in 2005, and we got married in 2008, and our young son, Nicolas Scott Brann, was born in September of 2009. And while, pardon me, it's a very emotional topic. While my son was everything to me and to my ex-wife, it was obvious that our marriage was starting to fail. And in 2012, in September, my ex-wife petitioned the Harris Court for divorce proceedings. She petitioned Harris County to be the jurisdiction, and she filed for joint custody, and she cited irreconcilable differences. In 2013, she asked to be able to take Nico down to Brazil to visit her family and to attend a family wedding. Her only brother, who lives in Houston as well, was getting married in Brazil. And because we were going through a divorce, and because I was acutely aware of the possibility of Nico being abducted down there, and because I had heard of the Sean and David Goldman case, I did everything that I could, I felt, to protect myself. So we had independent court evaluators evaluate both the mom and the dad and the child. We had an amicus attorney who was involved with the case who evaluated the mom and the dad and the child. And with the court, we eventually agreed to allow my ex-wife to travel down to Brazil to visit her family, but only doing so after she signed a travel agreement, a very detailed travel agreement. And in this agreement, she agreed that she would be down there for a specific amount of time. She would return on a specific date. And there was no question in that agreement that the habitual residence of my child was in Houston. She told the independent evaluator and the amicus attorney that she would be down there for that amount of time, sought their approval, sought their permission, and eventually I decided to allow her to go down there once that travel agreement was signed. And in my mind, I felt like I had done everything that I could to protect myself. All of the documents were set. There were 6 months of litigation that had gone on where this case had been evaluated, and there was overwhelming documentation that she'd agreed that Texas was the home of Nico. On July 1st, she was given permission after signing that travel agreement to go down to Brazil and was supposed to return on the 20th. I then received some correspondence from them where they said they'd like to extend their trip for a week. I didn't really have much choice. They were already in Brazil, so I agreed. Subsequently, unbeknownst to me, I found out that within a few days of being down in Brazil, she had petitioned the state court for sole custody, told the state court that I was incapable of caring for my child, and within a few weeks, which is, in my opinion, some amazing agility for the Brazilian court system, was able to obtain sole custody of my child. And I was never told. This was an ex parte decision, and I didn't actually find out until August 3rd when I got a phone call from my attorney, and he simply stated, "Chris, they're going to run with a child." And those were his words, and they've been running ever since. So as you can imagine, in fact, there's only one person in this room who can imagine what it's like, other than me. The feeling of knowing that you've done everything that you can to protect yourself, and despite that, being told that not only was your child abducted, but that it was premeditated. I subsequently found out that although my ex-wife had signed a travel agreement on May 20th, she'd actually enrolled my child in a Brazilian school in April. She had already accepted a job at a school in Brazil for an employment. And the kicker of this is that the school is owned by her family. Her mother and her aunt signed documents stating that my child had been in Brazil for months in order to show the Texas state court that they had achieved a level of residence, that they'd been down there. Those documents were actually notarized by the school, that my child had been in school since April, despite the fact that Interpol proved that they arrived in the country in early July. So not only is my situation one of those where my child is abducted, and it's done with amazing, overwhelming evidence prior to the abduction that she agreed to Texas being the home state, but it was done using falsified and fraudulent documents in a state court in Brazil. And now, almost 2.5 years later, despite the fact that there have been over eight independent evaluations that I'm an excellent father, and 8 or 10 evaluations, if you will, that my child was illegally taken to Brazil, and that his retention is unlawful, the federal judge ruled that my child should stay in Brazil. And ironically, she cited to the Sean and David Goldman case as the justification for keeping my child in Brazil. And I'll let my attorney explain the legal parts of that, of how ironic and twisted that is, and I'll let him to get into the legal details of that. But for me, the part of this story is personal, and the personal part of this story is that not only was my child taken, but now that he's there, I went from a situation where I had 45 to 50% of custody of my child to now a position where I have less than 1% physical custody of my child, and it's under armed guards hired by the family. And in a state court that not only has refused to answer the 6 formal petitions over the last 2 years to have a hearing, but over the last 16 times that I have been down in Brazil has refused to even meet me, refused to allow me a hearing to even explain my side of the story, and a judicial system that has refused to look into all of the wrongdoings that have occurred. So the last part of this that I want to say is a direct comment actually to my ex-wife and her family. I'm seeking what's in the best interest of my child. I'm seeking that he have the opportunity to have both parents in his life. I'm seeking that my son be returned to a situation where he has access to his overwhelmingly loving extended family in Texas. I'm asking that he be returned home. And I ask that you please think about what's best for him. It's not fair to him that he's had a loving parent removed from his life. And I am one of thousands of parents with thousands of children that are in a similar situation. And the reality is that the Brazilian system not only has ruled against me, but even if they do rule in my favor, it is almost impossible to enforce. And so that's the scary part of this situation. Thank you so much for your time. I'll now turn the time over to my attorney, Jared.
Congressman Smith, we introduced you in absentia.
Good morning. Good morning. Thank you, Chris, for the inspiring and courageous remarks. Having spent now more than 2 years working with you to secure Nico's return to Texas, I've seen how during the worst and most painful episode of your life, and your willingness to forgive Marcelli and insisting that Nico be returned into the joint custody of both of you, an extraordinary demonstration of why you're such an exceptional father. And it's because for you, it's always just been about Nico and never about your conflict with your now ex-wife. My name is Jared Genser. I'm an international human rights lawyer. I'm here today to talk about the legal issues in Chris Brann's case and the challenges we face ahead. I'm delighted that Sergio Botinha is with us, who's our local counsel, one of 2 local counsel who have struggled valiantly to persuade an uninformed and frankly disinterested judiciary in Brazil to follow its obligations under international law, and he'll be happy to talk to people later as well. So this case is governed by an international treaty called the Hague Convention on the Civil Aspects of International Child Abduction. It has close to 100 state parties, including the United States and Brazil. Its provisions are actually remarkably easy to understand, and in this case, the government of Brazil and the government of the United States agree that it requires Nico Brann's immediate return to the United States. Yet, inexplicably, federal judge Arali Maciel Duarte not only interpreted it wrongly, but she relied on an early decision in the most famous case in the history of the treaty, the Sean and David Goldman case, to deny Nico's return to the United States, even though the Supreme Court returned Sean Goldman to New Jersey more than 5 years ago, coming up on 6 years now. But it isn't merely that Judge Duarte has committed the equivalent of judicial malpractice, or that she was grossly negligent. In fact, she directly turned down repeated opportunities to get educated about the treaty, including a study trip to the United States and repeated offers to meet with the Brazilian Central Authority, which is part of its foreign ministry. So what does the treaty say? Quite simply, if a child is illegally taken or kept and the left-behind parent files a claim within 1 year of the abduction, the child must be returned unless there is a, quote, grave risk of imminent harm if the child was returned. It further states that a decision should be made on a child's return within 6 weeks of the case being filed. In short, it's a very simple jurisdictional treaty that does not determine what the best interests of the child are in any respect whatsoever. Instead, it exclusively determines in what jurisdiction should the question of the best interest of the child be determined. So, in applying this to the Brann case, 8 independent experts, including the government of the United States, the government of Brazil, the Texas judge, and the federal judge in Brazil, all agree that Nico was illegally taken and retained. So what is the grave risk of imminent harm and how would it apply here? The jurisprudence of the Hague Convention around the world has established that this provision is to be narrowly interpreted. It applies in 2 specific situations. The first is where the child will be placed in imminent danger by being in a geographic location, such as through war, famine, or disease. And second, it can apply where a left-behind parent has conducted serious child abuse or neglect that places a child in an intolerable situation, and that the government in question is not capable of protecting that child. It isn't sufficient for an abductor to allege these risks, but they must, with actual evidence, prove a grave risk to the child. And most importantly, the jurisprudence also establishes unequivocally that the potential damage caused from the return itself is excluded from the consideration of risk. And this is because of a general principle of law that precludes wrongdoers from profiting from their own crimes. In addition, it's actually also considered that such damage is not from the return itself, but actually from the necessary action to right the past wrong of the illegal removal in the first place. And in this case, the analysis on grave risk of harm is undisputed. Even Judge Duarte concluded that Chris is an excellent father and that he poses no risk, in her words, to Nico or to anyone else, relying on an expert opinion from a Brazil court-appointed psychologist that she appointed to review the case. And all of the independent assessments conclude Chris is an excellent father. Inexplicably, the judge took almost 2 years to render her decision, well beyond the 6-week limit for her to decide. So what was her basis for denying Nico's return? First, she claimed that Nico is well settled in Brazil. The other exception to deny a return can only be invoked if a left-behind parent delays more than a year to file a claim. And Judge Duarte points to an old Goldman case, the old Goldman case, exclusively to argue that even though the plain language of the treaty says she can't invoke this provision, she believes she can anyway. Because, she claims, the Constitution of Brazil says the best interests of the child are paramount and therefore can be applied in any circumstance. Judge Duarte also claims, as concluded in the old Goldman case, that the child could be damaged if returned to the United States, not from the environment or from a relationship with his father, but from the mere fact of the return itself. Both of these arguments were later rejected by the Supreme Court of Brazil, which sent Sean Goldman home in December of 2009, on Christmas Eve. It's bad enough that Judge Duarte was utterly incompetent, but she also chose to remain ignorant of the convention, declining to attend a judicial training course in the United States. Still, although this turn of events is inexplicable, what has happened in the state court in Brazil is unimaginable. Under the Hague Convention, the only question to be examined is what jurisdiction should the question of custody be determined. It is a flagrant violation of the treaty for any country to make any orders of custody as a Hague case is pending. In Nico's case, Marceli filed an ex parte claim for sole custody on July 10, 2013. She made no mention of the Texas proceedings or the travel agreement and made numerous other misrepresentations. On July 22, 2013, the judge awarded Marceli sole custody. Our local counsel informed us that it would usually take 6 months for a hearing to take place in the state court in Salvador. In this case, it took 12 days. The state court has also just accepted at face value a range of nasty claims that have been made against Chris by Marceli and her family, which had been rejected wholesale by the Texas courts and the independent experts. And as a result of the acceptance without the ability to challenge any claims, Chris's visitation was dramatically limited. Today, despite there being 8 experts from Brazil and the US that agree Chris is a great father and has a fabulous relationship with his son, Chris has less than 1% physical custody, supervised, and from 2 to 4 armed guards with him at all times. Even Judge Duarte says Chris is a great father, and Chris doesn't pose a danger to his son and anyone else. Yet State Court Judge Dorilda Oliveira Meyer stands firm, having rejected 6 requests for a hearing in order to even evaluate the decision of sole custody and the restricted visitations. The fact is that there's no evidence to deny Chris time with his son, and many, including even the court-appointed psychologist in Brazil, who say he should be given more time with his son, which has proven utterly irrelevant. So where do we go from here? And to wrap it up, there are 2 routes to get Nico home. As mentioned earlier, our local counsel, Sergio Batinha, is here. and could answer any questions about the local process in Brazil. But the first way to get Nico home would be to go through 3 further appeals and hope that the Supreme Court rules in the right way. It could take 2 or 3 years to reach that final outcome. The second way for Nico to come home is for Michele to decide at any time to get on a plane back to Houston with Nico to return to the joint custody of her son with Chris. From what I've described, I'm sure it seems difficult to imagine that this could happen, but the Guimarães family has, in my view, left itself highly exposed by the impunity with which it has operated. And this provides legal and appropriate ways for the government to incentivize the family to send Michele and Nico back to Texas. Let's begin with the role of Escola Nova Nossa Infancia. This is the primary school founded and run by Jemima Guimarães, Michele's mother. In the state court in Brazil, Michele filed a document showing Nico was enrolled in the family school on April 8, 2013. The document was signed by her mother, and her aunt. Michele didn't even sign the travel agreement until May 20th of 2013, which demonstrates she knew that the agreement that had been filed in the Texas court, she was not being truthful. Later in the federal court, a different version of the identical document was filed. The document from the school, now signed by Michele and her aunt, showed Nico enrolled in school on July 10th, 2013, after they arrived in Salvador. Both filings were made by the same lawyers in different courts in Brazil. It's self-evident the second one is a forgery. Under Brazilian law, the Education Ministry has the power to initiate an investigation into the accreditation of the school, which appears to have engaged in premeditating the abduction of a child across international border and forged documents to be filed in a federal court in Brazil. Surely it is both reasonable and appropriate for the Education Ministry to want to ensure that schools, which are supposed to be safe havens for children, are not being used to the criminal ends that endanger children. Now let's look to Carlos Guimarães, president of EDF and Man Brazil, a large commodities trading firm. He is Michele's father. Using firm resources, including his assistant and emails, the day after the state court in Brazil had actually ordered sole custody for Michele, he sent Chris Brann an email with a changed itinerary showing that she would return with Nico, but at a slightly later date. Here's what federal judge Arali Duarte had to say about Mr. Guimarães' behavior. As per notification issued by the defendant's father, Carlos Guimarães, the defendant and the minor would fix residence in Brazil. It's important to emphasize that the conduct of the father was to support his daughter in the illicit transference of the minor, since besides informing the lawyer on that fact, he himself bought and altered tickets in order to create an illusion that she would be back in the United States. Although Judge Duarte did not note the methodology by which Mr. Guimarães had acted, it was through the aforementioned emails coming from the official email system of EDF and Man Brazil to Chris Brann and showing his assistant and he were operating, which enabled this to take place. In my view, it would be utterly reasonable and appropriate for the government of Brazil to announce an investigation into the involvement of EDF and Man Brazil and Mr. Guimarães, as president, engaging in the conduct of an illicit transference of a minor across international borders. It would also be reasonable for the government of Brazil to say that it would ban government officials from having any contact with anyone at the company until such investigation was completed. Unfortunately, the current approach of the government of Brazil is to tell us that we need to work through the court system. We have tried for years to lodge a criminal complaint regarding this alleged wrongdoing. I'm pleased to announce today that we will be seeing a federal prosecutor in Brazil, and we will be lodging a formal complaint against Michele Guimarães and her family, and EDF and Man Brazil, and the school, when we travel overnight to Sao Paulo and then on to Brasilia tonight. I'm personally very grateful that Assistant Secretary Bond is appearing with us today. It speaks volumes about the U.S. government's support for Chris Brann, but we also need President Obama to engage personally with President Rousseff to ensure the most creative options to persuade Michele Guimarães and her family to return to the U.S. with Nico. I'm also very grateful for Congressman Chris Smith, who has been the champion's champion in the U.S. Congress on behalf of Left Behind parents. His presence also is a great honor. He has so many people that need his help desperately, and his presence, again, is extraordinarily valuable. And obviously for David Goldman, I can imagine he never would have imagined, although we will hear from him shortly, that his case would be used as a lesson by the judiciary in Brazil to actually keep children in the United States, despite the fact that his son was returned to the United States more than 5 years ago. We, of course, also will need the State Department to use every option available under the Goldman Act to put pressure on the government of Brazil to bring Nico home, and we will look forward to updating you as the case proceeds. Thank you very much.
Good morning. I want to give you some background on how the Department of State and the U.S. government approach cases of this sort, the parental abductions of children from the United States or to the United States, and also to talk specifically a bit about our experience with Brazil. We place the highest priority on the welfare of U.S. citizens overseas, but especially on children, because they can't speak for themselves. They are completely dependent on the actions of adults. Within my Bureau of Consular Affairs, we have a Directorate for Overseas Citizen Services and an Office of Children's Issues. And that office includes staff who work specifically on international parental child abduction. We sometimes refer to that as IPCA, International Parental Child Abduction. The staff work with the individual families who either have had a child abducted across international borders or who think that that might happen, because we often have families getting in touch with us. They've heard about the fact that these sorts of things occur. They think they might be at risk for that within their own families, and they contact our staff to find out what should they be doing to protect their child, to make sure that they don't actually face this sort of situation. So we spend a lot of our time on preventing these cases. We also intervene sometimes when we are contacted by someone who says, my child is being abducted right now. I've come home, suitcases have been packed, I know my wife is at the airport, or my husband, or my partner, and what can I do? How can I stop this abduction? And we have successfully worked with law enforcement to stop abductions actually in progress on several occasions. We also work with the central authorities in other governments. This Office of Children's Issues is the U.S. central authority under the Hague Convention, and part of the way that the convention works is that each country does have a designated central authority, and they work together to try to ensure that when there are cases, bilateral cases between those two countries, they are taking steps to make sure that they're resolved quickly and appropriately under the terms of the convention which have been described. They provide up-to-date information for the public so that people who are thinking, I've heard about this and I'm going through a bad patch with my spouse and I think this could happen to me, what should I be doing? We have that information available to the public, and we are, of course, also available for people to call in. Ambassador Susan Jacobs was introduced a little bit earlier. She is the Special Advisor for Children's Issues. She has been in this position since 2010. She focuses specifically on international parental child abduction cases and on intercountry adoption. She has traveled to Brazil 6 times since 2010, specifically to talk to the officials there about this issue. I mentioned we have an abduction prevention team. We have a 24-hour duty officer who is always available. So if people call in at 3 in the morning and there is, for example, they think there might be an abduction in progress right then, they will be referred to somebody who takes that call and talks them through what steps need to be taken in order to get a court order if they don't already have one, and get in touch with law enforcement and prevent the travel. So we're working with law enforcement on that. There's also, for years, been a procedure that is available to all parents in the United States whose children are American citizens. They can register with Passport Services, also part of my bureau, to explicitly say, I don't want a passport issued to my child unless you contact me to confirm that I have agreed to the issuance of that passport. Now, it's also true that no minor in the United States can receive a passport without the explicit concurrence of both parents. But it can happen that someone comes in with what they claim is a notarized agreement from the other parent. And so this other procedure is an additional one where someone can say, call me to confirm that I have actually agreed to this if anyone comes in to try to get a passport for my child. So that the fact that we do require all minors in the United States to have both parents' agreement to the issuance of a passport, or literally any kind of passport service. If you have a child who already has a passport and they need extra pages inserted, we need the approval of both parents to provide that service too. We check again to confirm that both parents are aware of the fact the child's getting that service. As has been mentioned, the United States and Brazil are treaty partners under the Hague Abduction Convention, and the purpose of that convention is to stop the abduction of children across international borders. The purpose of the convention is to make it pointless for a parent who is thinking, I'm just going to take this kid or the children and we're going to go and I won't have to argue with the spouse. I won't have to deal with anything. We'll go to where I think I have a playing field that tilts in my favor. In some cases, people take their kids and try to hide them completely from the other parent. The point of the convention is to set up a process under which the child is promptly returned. And the jurisdiction in the place where that child was living is going to make the decisions about custody and anything else to do with the best interests of the child. But there's no point in abducting a child. If the convention works as it's supposed to, they come straight back and that jurisdiction. So I think it is important to emphasize that under this convention, there's no suggestion that the left behind parent, as we term them, is going to get custody. The fact is that that decision is going to be made by the court in the place where the child has had his habitual residence. We use all the tools available under the law, including démarches, which that's a diplomatic term. It means that we go to the official representatives of the government, let's say in this case of Brazil, to sit down and talk explicitly about our concerns with how they are conducting or meeting their commitments or failing to meet their commitments under the Hague Convention, which they signed. We also make public statements, including the one that I'm making today. We have 4 what we call network judges. These are U.S. judges who are experts on the convention. One of the challenges of the convention is that a typical family court judge in the United States or in most countries may never see a Hague Convention case. And if they handle one, it may be the only one they handle in the course of their career. And so the purpose of these expert judges that they're working judges in the United States who volunteer to spend their time assisting on this issue is they are a resource that judges can turn to and they can discuss with them how this process is supposed to work, what is supposed to be happening. We also use our network judges to deal and to talk to and to train and educate judges in other countries to understand how the process is supposed to work and to help them understand how things work in the United States. Because in order for this convention to work as it should, there does have to be a significant level of trust by the judge that's hearing the case wherever the child has been taken, that when that child is returned, there's going to be a serious, thoughtful judge who is making those final decisions on behalf of the child. In the view of many judges, who again may be dealing with a case like this for the first time, there's a sense of, I'm sure I can make the right decision for this child, I'll just keep him here. And so our expert judges, one of whom happens to be fluent in Portuguese and has long ties to Brazil. He was a Peace Corps volunteer there decades ago. He's maintained his contacts. He has a lot of contacts in Brazil. So he is very much somebody that is known and trusted, and his expertise is recognized. They are a tremendous resource for us. We have, since 2003, issued annual reports assessing how different countries are complying with the convention. And since 2003, we have cited Brazil specifically, how many times? I do know how many times, and I'm not seeing it in front of me here. I think it's 9 times for failure to comply with their commitments under the Hague Convention. Explicitly, we have been focused on the failure of the judiciary to meet that obligation to make a decision within 6 weeks, to focus narrowly and specifically on the question of where is the child's habitual residence, and is this a Hague case, and is there any really proven reason to believe that the child would be at risk if returned to the place of habitual residence. So this is an area where Brazil has been consistently falling short of the commitment. We've seen repeated cases where the family may wait, the left behind parent and family may wait for months or years to get a decision, and under the legal process in Brazil, every decision can then be appealed and appealed and appealed so that the process extends. We have invested a great deal of time and energy in working with Brazil to try to address this, partly by training judges, by providing opportunities for Brazilian judges to visit the United States, meet their counterparts in the United States, understand what our procedures are, and address some of the misconceptions that they may have about the services that are available to families in the United States. It's not unusual for the taking parent to allege domestic violence, and it's not unusual for officials in Brazil and in some other countries to think, well, then of course they should stay where they are because they wouldn't be safe in the United States. So we have also put a lot of energy into addressing that directly and describing the kinds of resources that are available to individuals in the United States, whatever their nationality, whatever their legal status, to protect them from domestic violence and to ensure that that would not be a reason why you have to flee the country and go somewhere else. So I think I promised I would stick to 5 minutes, and I am going to stop. I appreciate the opportunity to speak to you this morning and the opportunity to stand in support of Dr. Brann and others who are fighting to bring their children home in compliance with the clear expectations and the commitment that Brazil and other countries have made under the Hague Convention. Thank you.
Thank you so much. Congressman Smith.
Thank you very much, and thank you, Secretary Bond, for those very fine comments and for really taking so seriously, and the Ambassador Jacobs, so thank you for your work on this as well. Let me just say a few opening comments. Much has been said, and I don't want to be redundant, but every year, an estimated 1,000 American children are unlawfully removed from their homes by one of their parents and taken across international borders. Parental child abduction rips children from their families and whisks them away to a foreign land, alienating them from the love and care of a parent and family left behind. Child abduction is child abuse, and it continues to plague families across the United States and the world. The parental child abduction of Nicolas Brann to Brazil is a particularly egregious example of an act of parental child abduction and wrongful retention. You remember every day that Nico stays unlawfully retained by the abducting parent is wrongful retention. And that must stop because it is hurting Nico, it is hurting his dad, and it's hurting the rest of the family. Dr. Brann is a textbook example of a dad, of a parent, having done all in his power to inhibit Nico's abduction. Obviously, the court and the signatures that were procured from both sides when the vacation, as it was called, was undertaken, was not adhered to. So a big lie has been perpetrated that Nico would be returned. He has not been returned. And any court anywhere in the world, particularly in a country like Brazil, which does have the rule of law, needs to recognize that and to honor that terrible, terrible misrepresentation by the abducting parent. As I think you all know, David Goldman, who is here, spent approximately 5 years trying to get his son, Sean, back from Brazil. It was an arduous ordeal for Sean, for the family, and especially for David, because I know the agony that he experienced, which Dr. Brann is now experiencing as well. This should not be this way. And David, too, was a textbook example of restraint, of compassion, of love, just like Dr. Brann for his son. Did everything legally to try to bring his son back, where the court makes decisions, as Michele Bond, I think, mentioned a moment ago, and has been mentioned by others. And you know, it's about the place of habitual residence being the venue where a court makes the determinations about custody. This flies in the face of the Hague Convention, and Brazil, as we all know, is a signatory to it. But David at least offered hope, I think, and continues to offer hope to Dr. Brann and so many others, because he did succeed and now has a wonderful, loving father-son relationship with Sean, who is now taller than he is. But it's just a tremendous final outcome that we are hoping and praying Dr. Brann will experience as well. I want to thank Jared for his expert presentation. I was going to use a few of those details, but he, as usual, did a wonderful job. And I just want to finish with this. You know, the Hague Convention, when parties enter into it and are of goodwill, is a wonderful instrument, international accord, that helps bring children back. But when you get judges and you get people who game the system, in David's case, the family that was working the system knew the Hague frontwards and backwards and exploited it to the nth degree, and used arguments that they themselves had said were precluded by the Hague Convention during those legal proceedings. The fact that Judge Duarte is using a case that was overturned by the High Court in Brazil is unconscionable. You know, it's a case that's already been repudiated, or a theory, if you want, and it's being used again to the detriment of Nico and of Dr. Brann. Last year, the Congress unanimously passed legislation that I authored, the Sean and David Goldman International Child Abduction and Prevention Act, to add weight. It was a bipartisan bill. We had strong support from both sides of the aisle, but it was all about adding real weight to these requests to return, as well as for access. As you know, the actions prescribed by the law escalate in severity and range from official protests, demarches, through diplomatic channels, to extradition, to the suspension of development, security, or other foreign assistance. Now, because Brazil has been found to have a pattern of noncompliance, Brazil is susceptible, or at least sanctionable, is sanctions eligible. That has not happened. Perhaps it might happen sometime in the future. But it seems to me that when the tools are there, my hope would be that they would be used so that Brazil gets it, as well as any other country that we mean business. We're not fooling around. This is child abuse. Parental alienation, as we know, carries with it lifelong detrimental impacts to the child, as well as the rest of the family. But the child, who is the most vulnerable in this entire process, hurts and hurts for the rest of their lives. Finally, let me just say that Americans, particularly U.S. family court judges, who may be petitioned to allow a child to travel to Brazil on vacation, as is the case of Dr. Brann, as well as David Goldman. It was so-called vacations when they were really abductions called vacations. Our judges need to know that the first Goldman report, again, it made that designation. The supplemental data that's been released and the daily injustice endured by Dr. Brann and his son, Nico, make it very clear, hopefully to these courts, that Brazil remains unsafe for any child at risk of abduction. Thank you.
David Goldman.
Good morning. Thank you for coming, and thank you for having me here. I really can imagine what Chris is going through, and I am most likely the only one. Any mom or dad could only go so far to the depths of the pain that Chris feels every day. And I go back there and it's so painful. And you have to pull yourself up because it'll kill you if you keep in that world. We're not only asking Brazil. Chris isn't only asking Brazil and begging Brazil to return his son Nico. He's expecting the rule of law to be followed. I am deeply disturbed, however, that the situation for left-behind parents in the U.S., like him, remain very much the same, despite the fact that our president last year did sign into law the Sean and David Goldman International Child Abduction Prevention and Return Act. It does give our government a set of tools to pressure these non-compliant countries into following their international obligations under the Hague Convention. Did I hear 9 times Brazil was non-compliant? Could it be any more clear that quiet diplomacy is not working with that country? If there is ever a country that screams the need to have these tools used in this new legislation, is Brazil. Let's please set an example. Let's get Chris's child home. This law was adopted in part because of my own personal experience as a left-behind parent when my son Sean was abducted and taken to Brazil in 2004. At that time, I was still married to a Brazilian woman, and Sean traveled together with my wife to Brazil for a vacation. He was 4 years old. Once they arrived, she called to tell me our marriage was over, and she wasn't returning with Sean to the U.S. If I ever wanted to contact or see him again, I would have to sign over custody and a host of other demands. Needless to say, I was stunned, I was devastated. I spent the next 5.5 years fighting in the Brazilian courts so I could get my son back. While my case differed from Chris's in particular details, our situations are essentially the same. Sean was clearly taken illegally to Brazil, and the Hague Convention required his immediate return home. We say 6 weeks. The 6 weeks, if you read it over and over, I kept saying it's 6 weeks. Why isn't my son home? It's 6 weeks before they have to make a decision. If they don't make that decision, they have to notify us why that decision is taking longer. But the whole purpose of the Hague is an expeditious return to disrupt the child's life as little as possible, not keep the child there and then say to return him home is disrupting his life and rewarding the abductor. We can't help the abductors from doing that in most cases, as we see. We have tools in place, but we can punish the countries that harbor these abductors by willingly signing the Hague and refusing to honor their treaty obligations. I filed my case in a timely manner, and all the experts agreed I was a great father. Yet, just as Chris is experiencing, the Brazilian courts ignored international law and treated the case as it was a simple custody case. And they gave preference to the Brazilian national mom. I will never forget the day that Sean finally boarded a plane with me to come home in December 24th, 2009. It was Christmas Eve. It was our Christmas miracle. Those hours on the flight were some of the joyous that I had in my life. I had my son back. I had spent the precious 5 years, nearly 6, fighting the impunity with which the Brazilian courts managed to completely ignore their treaty obligations, and which the Brazilian government had fully accepted when it signed on to the Hague Convention. It was an uphill battle and often felt impossible. But there was nothing anyone could have done to keep me from fighting for my son. Today, I am very pleased that my son is home. He's doing great. He is taller than me. He's happy. He's healthy. He's a very good student. He made the varsity lacrosse team as a freshman. He's living a normal childhood, which was his destiny, and we can be father and son again. During my ordeal, I did learn that I was not alone. There are hundreds, if not thousands, of U.S. parents in the same horrendous situation in which Chris finds himself today. I co-founded the Bring Sean Home Foundation in March of 2009 with the goal of providing resources and individual support to those left behind parents. While my experience has led me to become involved in supporting left behind parents and hearing their stories. Sean and my personal story. Excuse me, can I have a water, please? Thank you. I could have never imagined that a judge could use my case to hold another child in Brazil. I'm here today to speak directly to Judge Arali Maciel Duarte. I'd like to tell you that while you may not ever watch the news or ever heard of my case, that my name is David Goldman. And the Supreme Court of Brazil ordered my son home to America more than 5 years ago. And Chris, let me by saying to you that what I said to myself every day for nearly 6 years, never give up hope. Never give up fighting your legal and God-given right to reunite with your son. And never stop believing that Chris will come home, that Nikos will come home, Chris. I won't leave your side. Congressman Smith won't leave your side. I hope our government does what it needs to and brings home Nico. Thank you. I'm sorry for being so emotional, but it brings me right back to where I once was when I was in Chris's shoes, and it is so painful. You have to be strong, buddy.
Thank you very, very much for certainly one of the most interesting and emotionally wrenching newsmakers, I believe, in the history of the club. With that, we will field questions.
If you want to ask a question, if you can just identify yourself as well.
Correct.
Cláudia Trevisan from the Brazilian newspaper Estado de São Paulo. You said that you want to use all the options of the Shannon J. Goldman Act in the case of Chris. I'd like to know what concretely could be done, and if the ambassador Brann thinks this is a case in which the Shannon Goldman Act should be applied, and if yes, in which manner?
Could you speak into the microphone, whoever?
It's more for the U.S. government.
He had asked what steps you think should be taken. I'm sorry, she had asked. Right.
To whom you were addressing?
I'd like to know, first to Jared,
Yeah.
which way he thinks the law should apply in this case, and then to the investor, if you agree that the law is applied, is a case where the law should be applied, and if yes, in which manner?
Look, I mean, there are 10 different options, sanctions available under the Goldman Act to be applied sequentially or in any order that the U.S. government deems appropriate to bring Nico home. This case is so incredibly egregious, and I think what I would just emphasize is that the government of Brazil does not have to wait for the court system to grind its very slow process along for years. There's a lot that can be done right now by making clear to the Guimarães family that it will not be allowed to act with impunity. And I think that by opening up the kinds of investigations that I was talking about, that will create a very different perception among the Guimarães family about whether they would like to sit around and wait for the courts to send Nico home, or whether they might rather strike a deal to enable Nico to return to the United States into the joint custody of both parents and have this all put behind everybody. And so we need the government of Brazil to do a heck of a lot more than just merely say that we need to wait for the courts. They have in their power lots of things that they can do. And my view is if they don't, then the U.S. government should be prepared to use every item on the list, up until the imposition of trade sanctions, if necessary, to bring Nico home. That was the intent of the legislation that Congressman Smith authored. This is exactly why David Goldman has been advocating for so many years on behalf of his son, is to provide additional tools to the U.S. government. And, we are very grateful that the Office of the Attorney General in Brazil and the Brazilian Central Authority have been supportive and have stood with Chris in court advocating for Nico's return, but it just isn't enough. It clearly is not enough. It has not been enough, and we need much more to be done.
Ambassador?
Thanks, Jared. The Goldman Act applies to every single case of international parental child abduction. It's not an act that applies if someone decides, oh, this is a really bad one. It applies to every case of where a child has been abducted by a parent across an international border. The goal, obviously, is to get the children home. The goal is to move to a situation where the Act works as it should, where the Convention works as it should, and the children come home as quickly as possible. And so what we focus on in each case, and these are not, it's not a clump of cases. It's not like children abducted to Brazil. These are individual cases with individual circumstances, and we are focused in every single case on what can we do to get this case resolved, to get this child home. And so, as has been described, there are a range of things that can be done. One of them is relentlessly to be raising the issue with the government, and that is done by our embassy, in this case in Brasilia. It's done by senior officials right up to the top of the Department of State, raising the issue of parental child abduction with foreign governments and sometimes raising specific cases. It involves some of the steps that I have described where we make specific trips to sit down and talk about that specific issue. Of course, we also talk to the embassy representatives here in Washington, pushing to say, exactly what are you doing? Now, I think it's worth mentioning. I've been working on this type of case now for, I don't know, about 20 years. And the countries that were our biggest countries of concern years ago when I was first getting familiar with this issue are not the same countries that are our countries of concern today. And I think that's worth mentioning because it is very clear evidence that the relentless raising of the issue and the efforts that have been invested in educating people about how this is supposed to work and what this convention is about and what the point of it is and how children are harmed by parental abduction and why it matters that this is done correctly. We have seen in several countries situations where we used to get no returns, and we got a lot of statements from judges saying things like, this child is fine here. Why send him to another country? He's going to grow up here just fine. And now in those countries, we get the good collaboration, the good understanding of what the whole point of the convention is. And I'm talking about countries like Germany, Switzerland. These are countries that we did not get returns from, and now we do. Currently, countries of concern include Brazil, Costa Rica, Japan, which is now a Hague country, but I can tell you for years that was a tough fight to get Japan to understand the value of joining the Hague Convention, and now we're in the process of trying to get them to comply adequately, the way they should, with the requirements of that convention. But these results they're real. Now, for the individual family, obviously Chris doesn't want to wait 17 years for Nico to come home. And so the long-term effort is important, but then the specific effort of working on the individual cases, there what you are focused on is what are the actions that are likely to make a difference in this case. If the issue is a failure of the judicial, or the judges and the courts to understand the convention, then the best result is going to come from focusing on getting those judges to understand what it is that we're about and educating them on the harm to the child of an abduction. There is a tendency in some countries to think the kid's with his mother, he's fine. That's not true. Children need both parents. Children need regular access to both parents, and children should not experience the disruption in their lives of an abrupt removal from what was home and a failure to be able to have continuing contact with their father, yes, but also with their grandparents and their aunts and their uncles and their cousins and the whole community that they are a member of. So the bottom line, I guess, is, first of all, that act applies in every case. And second, all of the options that are included in the law are options that are out there to be used, and our focus is on what is likely to make a difference, what is likely to bring results, and that's what we're working to do.
We have to leave, and I just have one question for you. We must leave because a presidential candidate will be the next speaker in this room, John Kasich. Ambassador,
John, he'll be okay.
pardon?
I know, John, he'll be okay waiting.
He'll be okay waiting. How many cases are pending now with the State Department?
There are approximately 1,100 pending cases.
Wow.
And it is worth mentioning, that's a lot. It's a big number. It's not 1,000 a year, because a lot of these cases are years old, as is the Brann case, for example. So there are new cases every year. There are some cases that are resolved every year. But the pool of cases that we're aware of, that people have brought to our attention and that we're working with the families to resolve, is about 1,100. Obviously, the number fluctuates a little bit. We haven't talked about mediation, but that is another area where we want to try to find ways to use that, because in many cases, a mediated decision to bring the child home can be achieved faster than waiting for court action in some places.
And those do not include the unreported cases, and I'm sure there are plenty of those.
Well, and I would say events like this help in the effort to get the word out to people that there is help if they are in that situation, and that there are things that they can do to prevent an abduction if they think they might face that situation.
Thank you.
Thank you.
We'd like to thank the panel, the very distinguished panel, and thank the audience for coming.